Welcome back to Speak Van Holding 247, etc. And if you like, subscribe and share. Good morning to all my subscribers. Thank you for subscribing. Last week, a subscriber of mine asked me to give my point of view on the KAITLIN Armstrong alleged murder of Anna Marie Wilson, the up-and-coming cyclist that lived in Austin, Texas. It was my intention to do that the very next day, but I became ill. So today I will give my input, my outlook on this case. Before I do, I'm going to roll some clips to put some context into what I'm about to say.
And while it is set for trial this fall, we are starting to see how KAITLIN Armstrong's defense team is trying to chip away at the evidence against her. In a new 178-page filing, it says that the affidavit for Armstrong's arrest included, quote, deliberate falsehoods and statements made with a reckless disregard for the truth. They argue that the affidavit included a heavy reliance on an anonymous 911 caller on information that turned out to be wrong. Armstrong's attorneys also say that police overstated the results of ballistic testing and that a police interrogation of Armstrong was illegal because police had not yet read her rights.
Hey, good morning, Amy. Armstrong's attorneys are basically accusing the Austin police of violating her constitutional rights. First by detaining her under false pretenses, then not reading her Miranda rights, then repeatedly ignoring her requests for an attorney, and they want a jury to see none of that interrogation.
This morning, a major twist in the case of the yoga teacher police accused of killing a love rival. Attorneys for KAITLIN Armstrong say these newly released images from her interrogation were part of an illegal arrest and that they raise serious concerns about the case. The photo is part of newly filed court documents trying to suppress evidence and obtained by ABC News. Armstrong's attorneys allege that one day after pro cyclist Maria Wilson was found murdered in May, the detective on the case took Armstrong into custody with an illegal arrest warrant and constructed an illegal interrogation, claiming they'd brought her in on a 2018 charge for allegedly failing to pay for Botox, but then asked her about Wilson's murder. Armstrong seen being led to the interrogation room in handcuffs by two male officers in tactical vests.
KAITLIN Armstrong's lawyers are essentially saying that everything generated from this in-cell interview, including video of her being handcuffed, should be thrown out of court, and are essentially arguing that she was set up for this interview to look bad, to look like somebody who might have been a killer.
Armstrong's attorneys also allege the detective failed to provide Miranda warnings and that transcripts of her detainment reveal officers ignored her 3 requests to have an attorney present, which included, quote, do I need an attorney here? And I should have an attorney.
As you can see, Armstrong's attorneys are attacking the probable cause affidavit, giving rise to the search of her apartment. That's one issue. Number 2 issue is failure to give Miranda warning, which involves an illegal interrogation. So those are just going to be 2 issues that I can just put together. Now, let me explain something. They don't have any direct evidence that that was her Jeep. It's just a black Jeep. Could have been any Jeep. No VIN number identified it. No license plate identified it. That's one problem. Number 2, they can't prove that she was in that Jeep. They can't even prove that that was her Jeep. Number 3, she don't have to tell her whereabouts at that time if she don't take the stand. Now, since there's no direct evidence, that doesn't mean there's no evidence. It just means that there's no direct, hardcore evidence to link her to the alleged murder of Miss Wilson. However, they also have this thing called circumstantial evidence, meaning if you on a jury and I'm on a jury, or they take a trial by judge, all a person have to do is draw reasonable inference that this person come up murdered, You fled the country, tried to change your identity, used an alias name. You had to commit it. Now I'm going to tell you like this here. Under these circumstances, if I was on the jury, would I find her guilty? No. And I'm going to tell you why. Because I'm not willing to bet my life that she's the killer. Because the circumstantial evidence in itself gives me doubt. Now, if I was somebody on a jury trial, didn't care about somebody's rights or the standard of the law, I would just say, yeah, I think she done it. But based on the law, the evidence, I couldn't say she done it. Based on the law. In my mind, what I think, what I believe, pushing the law to the side, hell yeah, she done it. But that's different. That's the difference when you're dealing with the law. So if I was on a jury trial, if I was a jury on somebody's jury trial, I would just say I can't vote to find her guilty. Because the legal thing, I'm looking at the law, the prosecutor burden, beyond a reasonable doubt. Beyond a reasonable doubt means, was she in that car? Did she really kill him? Because the neighbors heard no shots. You think if a person shot a shotgun, you would hear this. So this means that in my mind, it gives me doubt that it was actually her. She could have drove somebody with her in the car. That's the problem. See, when they trying to convict her, a lot of things gonna come up in the defense that, can y'all prove that she was in that car? No. Did she actually commit the murder? No. They don't know. So at this point, I don't know what she said when they detained her under the false pretense of a Botox charge. She didn't pay for some Botox at some point. But I can tell you this, under Franks versus Delaware, the motion that they're attacking the affidavit up under, dealing with the deliberate misstatements, the lies. If that motion is granted, first, before it's granted, if the judge finds that motion has the valid points laid out in Franks versus Delaware, which is fro plonge, the judge must schedule a hearing and give the attorney for Miss Armstrong an opportunity to point out and prove what they're saying. If they don't even meet them prongs, the judge don't even have to schedule a hearing. But I can guarantee you that the judge will schedule a hearing based on what they're alleging in the motions that the media has put out. I'm basing it on that. A hearing will be granted. Now, let me tell you, if they grant it, even though, this is crucial, even though they find that the lies and misstatements of the affidavit to give probable cause was false, it does not in itself invalidate the search and the fruits of that search. They must first identify the deliberate falsehood that they claim is material to granting. What they are trying to do is say, look, if they wouldn't have said this, if they wouldn't have lied about this, misrepresented this, there would be no probable cause, meaning you would have never be able to get the warrant to search Miss Armstrong's apartment. If they find that these statements are false and deliberately misstated, the judge say, okay, we're going to remove that from the affidavit. Now we will read the affidavit and see if it's still sufficient to confer a warrant that I issue. If they find that removing the falsehood, the misstatements, would still give them grounds for the search warrant based on the contents in the affidavit after that's been removed, then they could use that evidence. The probable cause would still stand. That's the crucial point here. The attorney for Miss Armstrong must meet that burden. And if they meet that burden, all the evidence goes out the window. The Miranda, they should win that. Now, once they throw all the evidence out the window that she gave against herself, it's purely circumstantial. And I believe if she go in front of a jury and the jury follow the law, it's going to be a not guilty verdict. But when you're dealing with a jury trial by, it can go either way, because a lot of people will say, look, if you didn't do it, you wouldn't have did this, and that. But you have to ask yourself this here. If you had to bet your life, if they had you sign an agreement that if you vote yes, she did, and it comes out later on in life that she didn't do it, that they can take your life, you would vote not guilty. That's how I approach anything if I'm ever called to a jury trial. If it was my life, would I bet my life on that? And that's how every juror should approach it. By the way, I'm just giving her attorney some game as well. Y'all have a nice day. That's my take on that Armstrong case.